switch over to live videos and everything, and to share or not to share. I mean, she's taking a hint from Shakespeare. So,
Hi everyone, I'm Anudi, and this is probably one of the rare occasions I won't be billing you for my consultations. Okay, because we're running out of time, I'm going to ask one of my friends to come and write something on the board. Now, before my presentation today, I asked some of the audience to come up with a poem. Right? This is to best explain what copyright law is about. I'm going to talk to you about copyright law and the best practices you can handle and best things you can do for yourself online, because I know some of us are bloggers and most of us are bloggers, and we all use Facebook and social network media, and some of us are photographers, and most of the questions that have been put to me have been how can I protect my copyright, or people have copied my photograph, there's nothing I can do about it. So let's just talk about that. So firstly, sorry, I'm very bad with computers, so if I do something, yeah, okay. What is intellectual property? I like my presentation to be a little interactive, so if I ask you a question, you're most welcome to answer. Anyone can tell me what intellectual property is? Sorry? Yeah, without looking at the board. Okay, so any creation of the human intellect, that is a thought process. But something you need to understand is that thoughts are intangible. You can't hold a thought, because I can think of something and someone can think of something here, and we could have both thought of the same thing, but it depends on who brings it into reality. So if I move on, intellectual property law establishes what is known as property rights of intangible things. That is, things you can't touch, you turn it into properties. Okay. Let's say I'm just going to ask my friend to come and write that poem I told you about. Sorry, about on the board. So, Rushda.
Basically, say you come up with the person who came up with, let's say, the automatic bread slicer, right? His thought is probably there for a while, but it took a while for him to bring that and place it on a table, right? So what do you think can be protected? Was it his thought, or was it the machine? Right. So it will be protected as a patent, but it is the entire process that is
eventually that comes down to be the bread slicer that can be protected. Are you with me up to that point? Okay, good. Right, so these are the main categories of intellectual property. There are a few more, but I'm just going to deal with this very briefly. I'll be focusing on copyright law today mainly. Patents are those rights that can be protected that are with regard to inventions. So it can be a new inventive step in the field of technology, but it needs to be in the field of technology. It's not just a new formula or a new method of doing something. It must actually bring the technology forward, as opposed to just doing something that has already happened, bringing forward something that already exists. Then trademarks, trademarks are those symbols or names that can distinguish one establishment from another, one institution from another, one service provider or goods provider from another. Right. Then trade secrets, you all know what trade secrets are. Some of us have to sign contracts so as not to divulge information after you leave employment. I know most software companies have trade secrets, so therefore as employees you're not allowed to divulge this information outside. So trade secrets can be protected. For example, KFC, Coca-Cola, McDonald's, they all have trade secrets. That's how we identify each of their products as being separate, and that's how they have a monopoly in their relative fields. Design rights, given the name, it's nothing to do with designing, but it's rather to do with two-dimensional and three-dimensional objects. So from the shape of a bottle to a frisbee, the rights that protect those shapes of things is design rights, right? So moving on, in Sri Lanka, the institute you can go to that protects your intellectual property law is the National Intellectual Property Office, sorry. And this is where you can go and file for registration of patents or trademarks, right? And we are governed by the Intellectual Property Act number 36 of 2003. So if any of you have any copyright issues, you can refer to this statute. Okay, copyright. Copyright exists to prevent copying of works. Okay, to make things simple for all of us, right? This work was done by 3 people, okay? But this can be copyrighted immediately. How is that? Because copyright comes to being the moment it is documented, okay? So here it was not when it was thought about, because I'm sure people had to think about it to come up with this. But you can't protect someone's thought. It needs to be documented. So the moment this was written on this board, this is copyrighted. Okay, so right now we're looking at a copyrighted work, and you can't take this out from here and say and use it for yourself. What is worth copying should be protected. I mean, it's up to you. If you think this is a fantastic poem and beats Shakespeare, then, you know, be my guest. You can say this is like a literary genius. You know, I couldn't have thought of a better poem. Or it just really depends on whether you want to. But in any case, this is now protected. And this is something interesting. Copyright holder has exclusive rights. I will come back to what exclusive rights is, but it's something we all take for granted because when we are creative and we put things on our blogs, we write poetry, we write essays, and sometimes we just use our blogs as a journal. You know, we've had a bad day, we want to vent, we go and write something on it, but that doesn't mean someone can take chunks of it and quote you without your permission, right? Your permission is absolutely necessary. And you know, copyright is something that is taken for granted all the time. I see this online all the time, where this symbol is not used. I couldn't stress on this more. You need to use your copyright symbols. Whether it's 3 lines that you've come up with, right? You need to use it, because you therefore, from that point onwards, will protect yourself. Should someone infringe, you can say, hey, look, it's there, right? Okay. Like, the work to be protected needs to be original. Being original means it needs to originate from you and not from some other place, you know, where you've seen it. Okay, give me a popular phrase, something that we hear often. Just
what's up?
Okay, what's up? Fine. You can't copyright what's up because it's obviously not original, and it comes from what is up. So, you know, you can't copyright, it needs to be original. The work needs to be recorded. That is what we did here. That is the only way you can copyright it. Okay? Protection must not be excluded on public policy. What is public policy grounds? Any clue? Okay, so pornographic items can't be copyrighted when put up on, let's say, on a Sri Lankan blog. I don't know what the law, I mean, laws differ from place to place, country to country, state to state. But here, you can't copyright it and ask for your rights later, because it's obviously not allowed based on public policy. Okay, you got, okay, fine. Right. Right. Then the next problem or the next issue is authorship or ownership. The thing is, author is a person who creates a literary or artistic work. Now for this we had 3 authors, okay? So we had Ahmad,
The second row here.
Naveed and Sabrin, right? You should read this, it's quite funny. Right, authorship is, the 3 of them came up with it, so that would fall under joint authorship. The person who creates the work, and it creates the original work, and in this case joint authorship because there is a collaboration of 2 people, 3 people. The difference is ownership. Generally, on the moment we put this down, yes, it's all 3 of them the owners of this work. But the difference is when you are an employer, and when you're an employee and you're under an employment contract. In that case, what you create there, according to the employment contract, will belong to your employers. And some of us sign these contracts before we begin our employment. So I'm not saying that this would fall under that, but were you working for a creative organization where this is what you're supposed to be doing, the moment you put it on paper, it will belong to the organization. Okay, so that is the clear difference between ownership and authorship. The moment you start though, authorship and ownership belong to the same person. The only difference is when it's in the course of employment.